Welcome, everyone. Good afternoon. This is Chris Tanis. I'm one of the founders of Beyond Pay and Beyond Taxes. And I know you see 4 beautiful pictures up there, but for this webinar, for a variety of reasons, I'm the only one that's going to be moderating today, along with Liz helping me out. But as far as the people you see there, so I'll do my best to answer all your questions as we go through. We did receive a few preliminary questions, so I do have those. You can also add questions to the Q&A. Try to keep the questions in the Q&A box rather than the chat. That way we make sure we don't miss any. We have a pretty good crowd today. There's been a lot of changes, in the program and a lot of talk. And I think this new Payroll Protection Flexibility Act was a welcome move that Congress and the President made for small businesses. Closed a lot of the gaps that maybe they missed when they tried to get money going in a timely way. And overall, I think it benefits just about everybody that applied and received a payroll protection program loan. So moving on to what changed, I'll start with the standard disclaimer. It's not possible for us to cover every aspect of the law and for all of your personal situations. So we're trying to bring some clarity and some overview. I'm not going to go into real deep dive detail into the nitty gritty of the applications for forgiveness. We're going to go through them though in general. So we're not going to provide any legal advice there. And if you have an accountant or an attorney, if there's anything that you think is sticky or questionable, we invite you to ask them for advice as well. There's still Treasury guidance being issued, and as far as taxability and some the nuances, so we're going to see what happens there. And the lenders as well sometimes interpret things differently. So whoever you received your PPP loan from is going to be adding clarifications and instructions as well as time goes on. So that's probably a good source for you to understand what they're going to be requiring. And with that, there's already a change that just happened last night. It's not actually a change, it's a proposed change. So just last night, the Senate passed a measure to extend the application window 5 additional weeks. So that's basically for people that haven't applied yet and would still like to get a PPP loan. They're trying to convince Congress and then President to extend that to use up some of the money that hasn't been used yet. In addition to that, there's a lot of talk about passing a second round of PPP loans. It's very preliminary right now, but the focus for those would be on smaller companies with under 100 employees. So I think basically what happened is that when they first came out with the PPP and the shutdown, they expected it, and everybody expected it to last, to be a lot shorter than it ended up being. And since there's this kind of limbo, extended shutdown and starts and stops, and it's really put a lot larger burden than they expected. So there may be another round of stimulus that goes out to smaller companies. So that could be an interesting thing to see for under 100 employee companies, if it's a forgivable program that could be helpful. We have a number of clients that have also taken advantage of the EIDL loans. So even if you went through and you got an EIDL advance of $10,000, you can also apply for an EIDL loan, which does have to be paid back. It's not forgivable, but it does provide very favorable terms with long-term payout, some cases over 30 years with a very low interest rate. So that's something to look for if you're still struggling and need some additional help, and you're not able to wait to see if they come up with more PPP money for smaller companies. So a few things that changed to add more flexibility. They extended the covered period from 8 to 24 weeks after the date the loan is funded. So it's pretty straightforward, even though the way it reads is a little confusing. Everybody gets 24 weeks. If for some reason 8 weeks is good enough for you and you've used you're 60% or you're 75% and you're ready to apply for forgiveness and your lender's ready, you can go ahead and do that. You don't need to take the full 24 weeks. But for most companies, the 24-week will probably be a more flexible period. And basically all it does is give you more time to spend even less money. And we'll get to that in order to qualify for full forgiveness. They've extended the program period to December 31st. So that basically means that whenever your loan is funded, you have 24 weeks from that point or December 30th to spend the money. But it's the earlier. So if you got an early loan and you choose the 24 weeks and that ends sometime in October or November, that will be the end of your program period, not December 31st. The requirements for payroll costs are lowered to 60% to qualify for full forgiveness. So that's a really welcome change. It's going to make it a lot easier, especially so they expanded to 24 weeks and reduced it to 60%. So that's going to kind of grab a lot more people without you having to really micromanage exactly who you're paying and how much you're paying them and play the game of trying to increase wages. This will help capture a lot more people into that full forgiveness. The less than 60% still qualifies for partial forgiveness. So this is something that wasn't clear in the previous law. It was 75%. And I think the intention was that you would get a prorated forgiveness if you spent less than that. But the way it read, they could have enforced it as a drop-off. If you didn't spend 75%, you didn't get any forgiveness at all. So they clarified that even if you only spend 50%, you would still get a proportional forgiveness. They clarified and strengthened the safe harbors for loan forgiveness for employers unable to return to normal business activity for the remainder of the year. So this is something that was also clarified, and we'll probably touch on it more in the Q&A as we get to the application. But basically, when the original law was written, you had to spend 75% and you had to maintain your FTEs or rehire them by June 30th. And if one of those conditions weren't met, the way it read is basically you lost your forgiveness. And so this says that if you weren't able to return to full normal business activity during the year and then the FTE part of it is waived and you only have to go by the 60% rule. So we'll see some of those options in the when we get to the applications. The other thing that was clarified was and changed a bit was the good faith standard was set for attempts to rehire employees or hire new similarly qualified employees. So before, the Treasury issued regulations after the law that said a reasonable standard, and the good faith standard is a little easier for you to justify. Basically, you ask if someone wants to come back. If they say no and you document it, you're good. That will help for people that don't meet the FTE requirement. The increase the maturity for the payback of PPP loans that aren't forgiven from 2 to 5 years. So the way that reads is it's automatic for any loans that were received after June 5th. For loans that were received prior to that, your lender has to agree to extend the payback from 2 to 5 years. So I don't know how the lenders are going to respond to that. My guess is they'll be pretty generous. I don't think it hurts them one way or the other. They extended the deferral period of the day the SBA responds with the approved forgiveness amount to the lender. So what that means is previously there was a drop dead time when you had to start paying back your PPP loan regardless of when you got it. This basically says you have 10 months. I didn't put the note in there, so I don't know the exact number. I'll try to look it up for number 8. But the period you can defer and not start making payments doesn't start till the lender gets back to you and says, no, you weren't forgiven for this amount. This is the amount you owe. And then you have a certain amount of time before you have to start paying back. For number 9, the other change, employers have 10 months from the end of their covered period to apply for forgiveness. So basically, if you choose 4 months or 24 weeks. That starts the day the money hits your bank account. When that 24 weeks date hits, you now have 10 months to apply for forgiveness. If you don't apply for forgiveness in those 10 months, then you'll automatically be required, forgiveness will be forfeited, and you'll automatically be required to start making payments based on the required schedule. PPP loan recipients can now also defer payroll tax payments. So originally, you couldn't do both, or you had to stop deferring your payroll tax payments once you got a PPP loan. They waived that, and so now you can do both at the same time. It relaxed the rules for those with criminal convictions. I won't go into the details of that, but it made it easier for people that have had felony convictions to get PPP loans. Forgiveness still reduced by an EIDL advance receipt. So if you got the $10,000 or some portion of that, you automatically comes right off the top of forgiveness, of your forgiveness, and that's part of the application. And another just technical matter, all the provisions are retroactive back to the beginning of the CARES and PPP Acts. So another new thing is they streamlined the application for forgiveness to a 5-page maximum application, but then they also added a new EZ application. And so that's going to streamline things a lot even further. And we're going to look at both of those and go with a quick overview of them. But the idea is if you're self-employed and you had no employees, or if you're willing to assert just with a statement that you didn't reduce the salary or wages of your employees by more than 25% and did not reduce the number of hours by 25%, or your business was impacted as a result of the health directives and do not reduce salaries and wages by more than 25%. And then you complete basically a self-certification that says, I agree that I did all that. You don't have to provide any documentation, and unless you're audited, they're just accepting your word that you met all those requirements. Obviously, if you become audited or reviewed and you didn't meet those, there'll be some sort of penalty, and they assert that they can assess criminal or civil penalties or both for not meeting that. The other possibility is that you just have to go through the full application and see if you would apply. So the key here are the 2 middle bullets. It took me a while to even get a handle on this, and this comes into the safe harbors that we're going to talk about when we look at the application. The difference between those 2 bullets. So basically, the second bullet, I would think, applies to almost no one, because in order for the second bullet to apply to you, it means you weren't affected at all by COVID. Your business went on just like normal with no reduction, and no effect by the authorities. I'm not sure, when we probably have a couple of customers in certain areas that maybe weren't, but the vast majority of our companies were in regions that had some sort of shutdown for a period of time, or partial shutdown, or employees that had to work from home. So it's very generous in terms of what they mean by business impacted. So most of you are going to fall into the category of the third bullet. Business was impacted, and therefore if your business was impacted and you managed to not reduce your salaries and wages of your employees by more than 25%, you can do this EZ application. So how do you measure the 25%? So the 25% is measured against a comparison period, which is January 1st to March 31st of 2020. So basically you take your 24-week period, assuming you chose that, you come up with what your average wages were for that period, and you compare it to those 3 months, the first quarter. And if that drop is less than 25%, then you would qualify for the EZ application. And it's the same with the FTEs. If you were part of the second bullet applies to you, you would do the same thing. You would take your FTEs and you would apply the same math. So this is a little different, and it wasn't clear in the previous law. It doesn't compare to the period you use to calculate how much PPP loan proceeds you were going to get. So I have a client that I was working on this with, and this was a case where when they used their 2019 payroll, they just happened to be they had a couple of additional programs they were running back then. They had a lot higher payroll in 2019. So when they applied for the PPP, they got a bigger number, and getting to the that 75% was going to be difficult no matter what, even without laying anybody off. They didn't lay anybody off, but they were already close to 75% of capacity because of some program cuts from the prior year. This changes that and compares it to what happened in 2019. So it can be kind of a secret hidden benefit for companies in that situation. If your payroll was higher in 2019 and already had dropped by January of 2020, it just makes forgiveness that much easier. And we mentioned the self-certification, the potential penalties for that if you're not truthful. These will be in the recording that you'll get at the end of this, and they're also at the end. We'll show them again at the end of the slide. These are basically links for the different applications. All right, so back to PPP payroll costs. Not much of this is changed other than the 60%. So what's included is still the same: employee benefits, state and local employer taxes, not FICA or Medicare, and everybody is capped with the $100,000 annualized cap. For shareholders or LLC members, they are still, so the rule is still basing it on 2019, your 2019 profits, or your guaranteed, the sum of whatever your self-employment income was in 2019. That's the max on an annualized basis that you can take as part of the forgiveness for payroll towards that 60%. So if you gave yourself a raise, if you're self-employed or you're an LLC member, even if you have employees, but you increased your pay to try to get you to that 75% or that 60%, you're still going to be limited to what you had in 2019. So for some reason you had no profits in 2019 and no money, you can't increase your payments. For employees, that doesn't apply. You can increase your employees' payouts over the 24-week period versus what they got paid last year, and still count it towards the 60%. Utilities, not much has changed there. It does, something they did clarify is it doesn't matter when they're paid. It's kind of paid or incurred. So if for some reason, if you got oil delivered on the last day of your 24-week period, you didn't pay it till the next month, as long as you can show that it was delivered, you're going to be fine. Or if you paid for your oil at the beginning of the period for a prior period, that would count as well. What they're not allowing for rent, for mortgage interest, for utilities is any prepayment. So you can't purposely prepay several months to boost up your utilities costs. It has to be a reasonable amount that was consumed within that period. All right, so I'm going to just answer this question that popped in since we were just on the shareholder question. It's about shareholders. So shareholders' pay does count to the 60%, but only to the extent of the 2019 amount. So you take your total pay for 2019, divide it by 52, and then multiply that by 24, and that's going to be the max that you can apply in 2020. So basically, you can't give yourself a raise, whether it be in distributions or in profit, and have it count towards the 60%. All right. Utilities. So use of funds, that hasn't changed. have to be used for all the things, for utilities, for mortgage interest, for and for payroll purposes. All right, so let's look at the applications. We're going to start with the EZ. Let me zoom in a little bit. Liz, is that visible for everyone there?
I go in just a little bit more if you have the space on your screen.
Okay.
Yep.
How's that?
Great. Perfect.
Okay. So this is the EZ form. So going through the EZ form, most of this is demographic information at the top. Your covered period is the 24 weeks. Alternative covered period is you can choose a different period if for some reason you wanted to, but the covered period generally is 24 weeks from the date you receive the funds into your bank account. More than 2 million. So the forgiveness amount calculation is basically straightforward, a few lines, adding all the different costs together. You're going to add them up. You're going to compare it to the PPP loan amount. If the payroll costs are within 60%, then you're going to get the forgiveness amount. The EZ requires you to certify the things we talked about. So basically, you're certifying that you've not reduced by 75%. Sorry, it was just something threw me there on the description. It's just explaining here what the general partners and what the so it talks about the 2019 compensation, and it talks about the individual caps, so you're not over $100,000. A lot of scary things here that if you check, that what they can do to you if you are not truthful. So here, this one is interesting the way they phrase it. So when they talk about it, when I've heard read interpretations of this, a lot of the calculations are done on a global basis for the 25%. But if you read this, it says more than 25% for any employee during the covered period. So basically, the way I interpret this, and you can check with your source, but the way I interpret this, even if you laid off or reduced one employee, then you technically can't use the EZ form. But that's something I'm going to follow up on. I was trying to get a firm answer on that before we started, and I couldn't. So that's something that maybe we can update with this list and let people know what the outcome of that is. So try to just look for any other highlights here. So here is that the safe harbors of choosing which one. So if you weren't affected at all by COVID, then you would, and you didn't reduce by 75% or by 25% your salary or your employees' hours, you would check here. For most other people, you were affected in some way. Only the 75%, the 25% reduction applies, and the FTE does not come into play. So basically, the gist of this, and we'll see this in the full application as well, the FTE requirement and the rehiring became much less of an issue because of the 60%. My guess is from the clients I've worked with, most are going to easily hit the 60%, and once you do that, then the FTE really doesn't become an issue. So when you get these links, there's some instructions, and the SBA has tons of information on their website as well about their forgiveness. So going to the full application, top part is basically the same. So here you have this FTE reduction quotient again that comes into play if you weren't affected at all by the shutdown orders within your state. And then again, the certifications are going to come into play. So PPP Schedule A, as every situation is going to be a little different. So my advice would be just to really just take your time and enter this information in, and go through the numbers. Again, because of the 24-week grace period and 60%, it doesn't seem like people are scrambling quite as much to try to capture a whole bunch of costs to meet the needs. Before, with the previous only 8-week, I know clients were trying to find expenses to get you up to the amount. With 24 weeks, most people are going to have no trouble meeting the 60%, as well as using 100% of the loan proceeds for rent and utilities and the other qualified costs. So the safe harbor, this has to do with the FTEs again. So this is similar to the qualifications for using the EZ form. If you weren't able to get to the full level activity during this covered period, you can check here and you don't have to worry about the FTE reduction. The list of the individual employees, that's something that we can help you with. That doesn't have to be put right on this form. It can be attached, and your lender will probably give you more instructions on how they'd like that delivered when the time comes. We've got a few questions about reporting in our system, and we've mentioned this on a couple other webinars. We made the decision not to produce canned reports, and we do have an export tool, and working with your CSR or one of our data specialists, we'd be happy to help you get the exact report you need with the exact numbers. Our experience was with canned reports from other services, that clients that were using other services, is that they just weren't correct. They couldn't be relied upon. Even when you bring them up, the small print that they put with their canned reports was basically saying you can't rely on this information. So because of the way our customers are set up with all the unique earnings codes and deduction codes, coming up with canned reports we felt would have been risky for you, that someone might rely on them without checking and then end up having a problem later. So we made the decision to work with our customers closely to help get the data they need and ensure that it's correct. So that was one question that we received. I'm going to look at a couple other questions here. Someone asked about alternative period. I think I answered that. I think that's if for some reason you decide not to use the 24 weeks, you can designate your own alternative period. The max 20,833 allowed for shareholders. That's basically the annualized amount. So that's where what they're doing there is they're making sure it's not over 100,000. Reduced wages, does that include a no overtime rule? I'm not sure what you mean by that. There is no limitation on overtime for calculating payroll. Although if you didn't meet the FTE safe harbor, that could affect your FTE reduction. If you just, if you let go of employees, but then had others work overtime. That could play into that calculation. So here's another question. We expected to have use funds in 8 weeks. Rules weren't changed, so we're nearly done with our 8 weeks, so we mostly used up the funds. In order to choose 24 weeks, would we need to keep payroll levels same through entire 24 weeks? No, I mean, as long as you meet the 60%, you're going to get full forgiveness. I guess thinking that through, if you decided just to lay a bunch of people off after 12 weeks, and you might have a problem with the FTE requirement if you didn't have to do that because of COVID. If you can't certify that you met the safe harbor because your business was impacted by COVID, then in theory you could get into issues there, and you'd probably be better just choosing the 8-week period. But in most cases, I can't think of a scenario where the 24 weeks wouldn't work out, because basically you're just getting more time to spend the 60%. Can you apply for forgiveness between the 8-week and 24-week period? If we exhausted money in week 12, can we begin the forgiveness calculation at that point? Yes, that's what the alternate period is. So I believe you can just go ahead, and when you're ready, if you want to get the jump on it and your lender is ready, then you can go ahead and do that. Do you include employees on maternity leave or disability and number of employees for employer? That is a good question. I know from a dollar standpoint, you only can count money that you've paid out. So if you're paying sick time, or if you're paying some sort of family leave and they're actually getting or vacation pay, if the money's going out, then that counts as dollars. And that would obviously also count as FTEs. But if someone's out on maternity leave or disability, I do not believe that that counts them as towards the FTE. As far as I know, they would not be included in that. If loan received on May 1st, what is the deadline for applying for loan forgiveness? So it's 10 months from the 24 weeks after May 1st. So May, June, July. So your 24 weeks is going to be roughly 6 months from May 1st. So November 1st. So you have until sometime August, September of 2021 to apply for forgiveness. My recommendation would be to apply as soon as you can, because the lenders are probably going to be backed up. If loan received on May 1st was a deadline for spending the funds, again, it's 24 weeks from the time you receive the money. Employed intern that left in 4 weeks, does this count as an employee salary reduced more than 25%? Well, you're not comparing to the current period, you're comparing to the January through March 31st. So if they were working January through March 31st and then they left 4 weeks into your covered period, then yes, that would calculate as someone that was as an FTE reduction, or a 25% reduction. Now, again, there is some confusion here as to what it means when people quit versus people that were laid off, and because you didn't actually reduce their pay, they were just left. So what I would do is I would go through the calculation and see how it comes out. And if it makes a difference, then consult an accountant to help you decide the best way to show that. But if you're going to get to the 60%, you're going to qualify for forgiveness. Your business was affected, so the FTE doesn't require. The only drawback here in this case is that you may have to do the long form instead of the easy form. which is part as I go through this, and I'm still digesting it, so I keep making these qualifications. You know, a lot of the problems now that I'm coming across basically boil down to which form you have to use, as opposed to whether or not you're going to get forgiveness. We did not let go or reduce hours, but most of our employees worked overtime since April. Are we no longer allowed overtime? No, overtime is fine. It counts as pay. It doesn't affect the calculations at all. Employees are allowed a max of 46,000 over 24 weeks, but owners are allowed 2833. So that's something that is throwing me a bit. So just bear with me a second. So what they did there is remember I said earlier that you could get a benefit if your payroll was higher because in 2019 than naturally than 2020. So basically what they did, they extended the 24 weeks, but they kept the cap at the 2.5 months worth of 2019 compensation. So they're basically not allowing owners pay to be included in that benefit if you had higher payroll last year than this year. So it looks like it was purposeful to basically limit the benefit of the 24 weeks for self-employed people. So that's something I didn't pick up the first time. So that's a good question. I'm glad someone pointed that out. So if your payroll dropped from 2019 to 2020, you got to apply for a higher PPP loan amount, but you'll still get full forgiveness even if your first quarter payroll was low. But they kind of mitigated that by putting a cap on owners. Can you speak to the current status on reporting other than employee expenses, utilities, rent, etc.? Well, we can go back to the slides. Most of the other expenses haven't changed very much as what qualifies. So phone, internet, electric, gas, water, the rent, or if you own your own building, the mortgage interest. One thing that they did clarify, if you own the building in a separate entity, so if you own your own building, in an LLC, and your business leases it from you, as long as you didn't change the amount of the rent during the period and the lease was in place prior to your PPP loan, or February 15th, I believe it was, you can deduct the full rent. You don't have to just take the mortgage interest. So the full rent, what you can't do is double your rent starting in March and include that. Again, now that they extended it 24 weeks, I don't think that's going to be a problem for most people. Utilities, again, they're being very generous. It actually says transportation in there. So if you are a company that uses fuel for vehicles, then that would be included. And you could probably interpret that to mean even auto reimbursement for employees, and the mileage would be considered part of utilities if you need that to get you up to the total. So again, I think these are going to be mostly exceptions for people that are just trying to get to that 100% with the 24 weeks. A lot of these subtleties, I think, aren't going to be an issue. Looking at the questions that came in prior to the webinar. The time period has been extended from 8 to 24 weeks. Could we utilize the funds as of 10 weeks of offer? Yes. All right. So that was already answered. Yes, you can file at any time. Loan received on May 1st. All right. So that was already answered. So this one, received PPP on 5/7. We are still not fully open and not on payroll, possibly next week or two. Our dollar was based on 6 full-time and 1 part-time employee. 2 full-time employees will not be returning due to personal reasons. What does that do to us with regard to repayment? Will we meet the original payroll? We won't meet. So, I mean, without having all the details, I would say just go through the calculations. But it seems to me in that situation that you're not going to qualify for full forgiveness. Now, what you could do is you want to make sure that you include your owner's pay. You know, if the owners are were part of that pay for the prior year of 2019, so make sure you use those maximums to help you get there and get as much forgiveness as possible. But again, you have until the end of the year to, you know, as you rehire people and spend that money, you might get a little bit closer. If you don't, you know, if you're not able to and you have to pay back some, you have 5 years to pay it back at a very low interest rate. What is the process to request change of funds from a loan to a grant? I don't believe that there's anything in PPP that allows that other than for the forgiveness piece, which may be the question. So it's filling out those applications, and whatever forgiveness will not be taxable. Does paying PSL or extended family leave count towards forgiveness during 8-week period? So paid sick leave, yes. Extended family leave, if you're paying them payroll, yes, but not if you got the, you know, the credit, the FFCRA credit under the CARES Act. That does not apply. You have to eliminate those. But other payments for sick pay, vacation pay, those are included. One more question came in the Q&A. Do we count employees in the FTE calc if some of our employees were paid COVID sick? So no, those, well, on the FTE calc, that's another good question. So we know that the amounts can't be included in the 25%. But the FTE. So I'm going to look for a resource. Just bear with me. I saw a resource. Just bear with me. Let's actually if I can get a quick answer here to that. All right, this doesn't give you information. So I'm making a note, and I'm going to try to follow up with an article or some links to put on our resources page for how to calculate and what's included in FTEs, because that seems to be a common question we're getting, and I just don't have really solid, confident answers on that. What I will say again, though, is that for most people, because of the 24 weeks and the 60%, and that most people were affected by COVID, that the FTE calc probably is going to be irrelevant in almost every case. All right, I don't see any other questions. So Liz, if you can just let them know, you know, when and where they can get the recording of this. And oh, 2 more popped in. All right, so one more question here. We didn't reduce hours or employees by one of our employees who has been part-time for over 2 years. worked on a specific project at the beginning of the year and temporary work more hours. We are his second job and could not work those out and could not work those hours now. He is back at his normal part-time hours right now. How does that affect the 25% for him? So again, part-time employees, and that'll be, basically you annualize their FTE. So there's a calculation you go through for part-time employees, and I would think that would just apply to that individual. And when you compare the totals to the to your reference period, the January 1st through March 31st, to whatever your covered period is, you'll just have to go through the calculations and see how it affects it. If you use the EZ form, will you simply have to certify non-payroll expenses, or you have to provide supporting documentation? The way I understand it is that you don't have to provide the supporting documentation, you're just certifying it. Now, the lender may still require to see it. So I think they've left that up to the lender. Will you providing a new updated spreadsheet? So I'm going to talk to Jack about that and see with the simplified form, the calculation is pretty straightforward. The hardest part is getting the amounts for payroll expenses, which your CSR is happy to help you with. So the calculation is basically only 3 lines, but I will check with him and see if he can update the spreadsheet.
Great, thank you. But like Chris said, I'll let you guys know where you can find the recording. It is going to be delivered to everyone's inbox directly if you registered for this webinar. And I'll also be getting that posted on our COVID-19 resource page within about, hopefully, the hour. That's at beyondpay.com. And if you go to our homepage, in the upper right-hand corner, COVID-19 FAQ is hyperlinked to that resource page. We also post all of these recordings on our YouTube page as well. So you can find our COVID-19 workplace webinars playlist there if you ever want to go back through and see past recordings that way too.
All right, and I'll just say one other thing because I'm feeling a little self-conscious about the FTE questions and not having great answers. I think the way to go about that is to go through the calculations, follow the instructions, and then see how it works out. I'm not sure there's much you can do at this point unless you're going to hire somebody that you don't need to try to fill the gap. But again, it's by going through the calculations, hopefully that'll answer your questions. All right. All right, well, thanks everyone, and stay tuned for more updated information as we get it.
Thank you.
All right.